cause number, the court will defer finding of guilt in cause number 2025 CR.
Here we go, folks. The courtroom is officially in session, and we're diving into a high-stakes case. Notice how the judge reads the case numbers. This sets the tone. Every little procedural step here could affect the defendant's fate. Pay attention, because the legal details are critical.
Court is calling 2025 CR 011859 and 2025 CR 011607, State versus Isabel Arias. Can I have parties announce?
Christopher Ramos for the defense.
Okay. And are you Miss Arias? Counsel, have you received all discovery and did you review it with your client?
I did.
Court will find that the state is in compliance in each cause number. And are there applications in each cause number?
Judge, only in the injury to a child cause number ending in 1859, there is an application for deferred and an application for community supervision.
All right. Did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it? And for the record, that's in cause number 2025 CR 011859. There are no applications in cause number 2025 CR 011607. Did you review the true bill of indictment in each of these cause numbers with your attorney? Did you understand them? Yes. Counsel, do you waive the reading of the indictments?
We do.
State in cause number 2025 CR 011607, are you proceeding on the indictment as presented? That is correct. Yes. So in that case, the state is proceeding on the.
Interesting move by the prosecutor. They've decided to go with a lesser included offense. That's a strategic choice, potentially reducing the defendant's maximum exposure. Watch closely. This tells us how the state is weighing evidence, and it can impact sentencing dramatically. What would you do in this scenario?
Lesser included offense of assault bodily injury as a Class A misdemeanor. Any objections from the defense?
No objections.
And state in the cause number 2025 CR 011859, are you proceeding on the indictment as presented?
You're not sure. We're proceeding forward on count one, waive count two.
Any objection?
What did the prosecutor say?
They said they're proceeding, they're waiving count two.
No objection.
All right. And each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in both places? Yes. Did you understand that in the cause number in 59, you're charged with injury to a child, elderly, or disabled person, bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. In that cause number, if I grant your application for deferred adjudication, if for any reason your deferred adjudication will revoke.
Whoa, heavy stuff here. The defendant is officially giving up the right to a jury trial and facing serious potential penalties, up to 10 years in one case. This is the reality of plea agreements. Sometimes they save you from risk, sometimes they lock you in. Could you make this decision?
I could sentence you up to 10 years in the prison and up to $10,000 fine. Did you understand? Yes. And cause number 2025 CR 011607, the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand? Yes. If you have plea bargain agreements with the state, I do not have to follow those pleas. If for any reason I do not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you are giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
And counsel, can you tell the court, was she ever evaluated for competency?
She was not evaluated for competency, but she has been able to answer all of my questions, provide a description of what happened. She has organized thoughts. She does appear to be extremely educated. So I did not have an issue with her competency. When I do review the reports, it appears that her behavior was the result of ingesting a particular controlled substance, and it resulted in these events.
All right, thank you. And I was just only asking because I couldn't recall whether or not she had been evaluated or not, but I do trust your opinion because you're her attorney. Thank you.
Thank you, Judge.
Thank you. Ms. Arias, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into a plea, you will be deported, denied naturalization, and reentry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney in each of these cause numbers? And did you understand the plea? And the cause number ending in 07. According to your plea bargain agreement, the state is proceeding on a lesser included offense of assault bodily injury. Punishment is to be assessed at 171 days in the Bexar County Jail. There's a $0 fine and no application. And the cause number ending in 59, according to your plea bargain agreement, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. The state is opposed to your applications. They're taking in consideration 2025 CR 011606 and 2025 CC 009996. There's an affirmative finding of family violence. There's to be no contact with Ilana Hernandez, Stacy Hernandez, and Florencia Plache. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be your plea in each of these cause numbers? Defense, is that the plea?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No motions, Judge.
And cause number 2025 CR 011607 to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? And cause number 2025 CR 011859 to count 2 of the indictment, how do you plead? I'm sorry, count 1 of the indictment. How do you plead? Guilty, not guilty, or no contest? State, any evidence to support the defendant's plea?
For both cases.
Any objections?
No objection.
And each of the cause numbers, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it and did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Guilty, but deferred adjudication applied. This is key. Basically, the court acknowledges guilt but pauses sentencing, giving the defendant a chance to meet certain conditions. It's a tense moment because any misstep could bring the full sentence down. This is where courtroom strategy and compliance matter most.
All right, after reviewing State's Exhibits 1 and attachments, the court will find that there's sufficient evidence to find you guilty in each cause number. The court will defer finding of guilt in cause number 2025 CR 011859 as you've applied for deferred adjudication, and cause number 2025 CR 011670, the court will find you guilty. In that cause number, are we proceeding with sentencing?
In the misdemeanor case, yes, Judge. Our hope is that court will find the sentence satisfied.
All right. And does she have the time in custody?
That is my understanding, Judge, 171 days.
All right, then, and cause number 2025 CR 011607, the court will find you guilty, sentence you to 171 days in the Bexar County Jail, give you credit for any time served. The court will show that the judgment is satisfied. In that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Let me give that to you. Thank you. With the other case, have you all had a chance to speak to the complainants? All right, thank you. So, Mr. Ramos,
Yes, Judge.
we can set this for a PSI and TAP evaluation. It will be brought back in 8 to 12 weeks because that's the time frame.
Yes, Judge, I
Or-
understand.
If you would like it brought back at the end of January, if you're waiving PSI and TAP, we could bring it back at the end of January and everyone can call whatever witnesses they wish to call.
Now, we see the tactical side of courtroom management. The attorney waives the PSI, speeding things up, while the judge sets a clear timeline for January. It's all about controlling how evidence and witnesses come into play. Courtroom logistics may seem mundane, but they can make or break a case.
So, what do you request?
Can we bring it back on, I'm sorry, what did you say about the TAP, Judge?
Oh, if you want a PSI, then it's going to be 8 to 12 weeks because that's the time frame. If you waive the PSI, then I can bring you back at the end of January, most likely the end of January. And you can call whatever witnesses, and the state can call whatever witnesses they choose to call. Usually at that time, the state will give me any type of criminal history that someone may have.
Okay, that's fair. So if we can set it the last week of January, we'll be fine with that. My understanding, she has no criminal history, so that's my biggest concern. But the last week of January will be good.
All right, so you're waiving PSI?
Formally, we are waiving PSI, Judge.
All right. Ms. Abrams, are you okay with doing this? On Monday, the 26th? Is that good? And is that good for you, counsel, the 26th of January?
Yes, Judge, I will be in Bexar County on that day.
All
Thank you.
right, I would do it later in the week, but I see on the calendar, I'm supposed to go to Almost Elementary School for Career Day. You know, last time they had an entire zoo there and a giant snake, and the lady was like, "You want to touch the snake?" I'm like, "I'm gonna pass on that," but I love all creatures, great and small. All right, Miss Arias, do you have any question about anything? So what's happened is your attorney has waived the PSI. So he'll bring whatever witnesses you want me to hear, and I'll make a decision on your application on whatever evidence is presented to me. And at that time, the state will have a chance to present any other evidence other than the reports I've received if they wish to do so. You have any questions? All right, so we'll bring you back at the end of January. All right, thank you.
Thank you,
Thank
Judge.
you. Merry Christmas.
Merry Christmas to you, Judge.
Yes. Yes, the 26th.
Thank you, Judge.
And is that the last case we have? All right, guys. Merry Christmas. Happy New Year. I'll see you guys in the new year.